Hello, hello. Hello. Hello, hello, hello. Ladies and gentlemen, could you please take your seats so that we kick off with the third panel? Those standing outside, could you come in, please? I know this is from lunch to the end of the day is usually challenging because during lunch we tend to indulge and eat plenty, which is a good thing because we need the energy. And I hope that we can concentrate and follow up what we have lined up for the next couple of panels today. While we hope that those standing outside will come in, we ask those inside to either switch off their telephones or put them on silence mode. The attendance sheets that we have on our tables, I don't think they've been completed to the fullest because some people came in late. May I ask people to try to complete, put their names on that list because they will be collected very, very soon. We have the third panel now ready to go. And I am going to now, they're already sitting here, but the moderator for the panel is Jacquel Ferris, who is sat there, director at Clive Jacob Hofmeyr. The speakers of the panel include Pierre Berger, director at Wakeman's Attorney, South Africa, Uche Ofo-Dile, senior fellow and endowed chair at Harvard University and University of Arkansas School of Law. Natasha Peters, partner at Trinity International, France and UK. And Gadi Ndahumba, chief legal counsel at African Legal Support Facilities in South Africa. The floor is yours, Mr. Moderator.
To just stand a bit for the first part of the discussion and the introduction. Good afternoon, everyone. I know this is the so-called graveyard shift, so hopefully we can live up the discussion a bit and have a more engaging session. If you're following on this morning's discussion, which was very engaging in terms of discussing arbitration generally, but also different forms of dispute settlement, and also what are the new forms of dispute settlement that practitioners and users of arbitration can look out for. The current panel, panel 4, the intention is to discuss dispute settlement in the form of future industries, the development of evolving of future industries globally, but also on the African continent. When we talk about future industries, we talk about industries that are evolving or that should be evolving on the African continent, whether it's green hydrogen, whether it's e-mobility, whether it's automation, whether it's AI, all of those future industries. And the question is, and that's the title of the discussion, is African practitioners ready? Are we ready to deal with it? And what is the requirements? Is it skills development from an ADR perspective, or is it skills development from a specialization perspective that are required? And we will have a debate and discussion where I am joined by esteemed colleagues from all over the world, whether it's from a client perspective, looking at it from an African context, whether it is from a law firm perspective in terms of what clients are doing in clean energy and future industries, whether it is from an academic perspective talking about what is happening on the continent, and not just on the continent, but more so globally, and whether it's talking about issues such as cryptocurrency and how that can be utilized also from a funding perspective on the continent, and then ultimately dispute settlement, because as we all know, disputes, whether it's in our personal lives or whether it's governments and investors or commercial parties, are inevitable. You have the honeymoon phase in the beginning, and then at some point the honeymoon ends and you have to live with each other. And in particular with long-term context, when we talk about major infrastructure developments in the energy space, in the infrastructure space, you need to cater for these things. So our discussion will be to unpack dispute settlement in future industries. So just from a housekeeping perspective, and I don't think I introduce myself broadly, but I'm Jack Will Ferris. So I'm a partner, as the president said, at CDH, or Cliff Decker Hofmeyer, also a firm that is based in South Africa and in Kenya, and have a number of relationship firms on the African continent and globally. So housekeeping, what we're going to do a bit differently than the other panels is there will be a poll, and you've been asked to download an app called the Slido app. So if you can please download the app, because at some point during the discussion, you will be asked to participate in the poll, and that poll will also result in further discussions. We'll also give you a code, so the code is on the screen, so if you can please do that for us. Then just some remarks before I start the panel discussion and introduce each of my panelists individually in terms of their specific discussion points. And slides have been prepared and they will be uploaded also on the Woza app. I know there's different apps being utilized, but that's specific for the conference and the program and agenda. So when we talk about future industries, and I mentioned hydrogen, I mentioned e-mobility, but if you look at the past 24 months, just post-COVID, there's been a proliferation in the talk around e-mobility, the talk about green hydrogen in particular, and what we talk about is the move of the globe to net zero, or at least low carbonization. And part of that is there are industries developing where Africa contributes less than 4% of the total greenhouse gas emissions, can significantly contribute to the decarbonization of the globe. But talking about that, it's also Africa is a continent that is blessed with resources in the form of whether it's coal, whether it's gas or oil. Where's the just energy transition issues that we need to deal with, and how do we deal with that in balancing decarbonization for the globe, but also dealing with our own economic development imperatives under the AFCFTA to achieve our economic development objectives, which is again part of the African Continental Free Trade Agreement. And part of that is talking about investment, talking about intra-Africa investment, and in talking about the principles that will be unpacked by the panelists, whether it's issues around energy, issues around projects, funding, ESG, cryptocurrencies, and how do we take everyone along with us. And again, the point is African practitioners ready to deal with it. So that leads me then to my first panelist, and I'm going to introduce. So Gadi Njamba is the Chief Legal Counsel at the African Legal Support Facility, an international organization hosted by the African Development Bank Group. He is responsible for the implementation of the ALFS's transactional support to African governments in the energy and sovereign finance sector. The ALFS work spans across the African continent and has been supporting the efforts to tackle energy deficiency through conventional and innovative technology. So Gadi, over to you to unpack the issues for us in a bit more detail.
Good afternoon, everyone. So first session just after lunch on a Friday 13th. It's going to be fun. So thank you very much for welcoming me today. So I will just introduce very shortly the ELSF, so you have an understanding of the vantage point that I will be speaking of. So the ELSF is the African Legal Support Facility. We're supporting African government. It's a facility that was set up by the African Development Bank. Initially, we were mostly representing government for vulture fund litigation, but we quickly moved towards transactional support. So any complex commercial transaction that will require some legal representation, we offer the service to government, to African governments, mostly on a grant basis, but also recoverable grants for for upper middle income countries. And we, at the moment, are working in 44 countries. We've worked since the inception on almost 50 of the countries, except South Africa, and we're still working on this, but most of the continent, we have projects. We work in the energy sector, the infrastructure sector, the extractive sector, and sovereign finance. My background is in the energy sector, and until recently I was only focused on energy projects across the continent. Obviously, a lot of renewable energy, as we all know, was developed recently. And I will focus on that sector to show some of the dynamics that the energy transition and climate change are pushing towards. So, if we're trying to make sense of some of the critical trends that are pushed by the energy transition, which is leading towards the future industries, we see a lot of decentralization. And when we talk about decentralization in the energy sector for African countries, we are multiplying the number of actors. So historically, the energy sector would have a utility. The utility will own the production assets. And as they opened up these sectors to include renewable energy, they often did it at the same time as including IPP projects. As you probably know, IPP are independent power producers, so foreign investment, in most cases outside of South Africa, coming from the private sector for a plant that will be operated by the private sector. So the decentralization is pushing towards an increased number of stakeholders, and the increased number of stakeholders, which will be detailed by Natasha just after, will push towards increased number of interdependencies. And these interdependencies, when they're unanticipated or hard to manage, will create some new disputes that we have not yet seen. So to illustrate these trends, I'm going to use one case study that happened a few years ago, and then we'll discuss what is currently happening and what is likely to happen in the next few years. So, just in case you have not seen the contractual universe of an IPP project, it is pretty much what you're seeing on the screen. So a lot of contracts which typically will have similar dispute resolution mechanism, except a few of these contracts, but which will try to find a way to channel any dispute into the same processes. These IPPs are obviously bringing a lot of potential for dispute, since you could have an issue for each of these contractual relationship. But one thing that is important to note is that in most of these stakeholders, you do have a contract, and in accordance to best practice and the standards currently in the continent, but for a few 2 decades, I would say, you would have arbitration to kind of settle this. I'm pretty sure this is not news to anyone in the room. So, based on that structure, one of the first one of the great case studies to look at for an interdependency that we had not anticipated at all is one of the Gambia and Senegal case. So Senegal had an IPP project, so entered into a power purchase agreement with a renewable energy company. The renewable energy company had agreed to deliver electricity to the Senegalese utility. The Senegalese utility is comfortable to manage a big part of the risk. As you know, these contracts will allocate the risk to the best placed party to manage it. In this case, what happened is that the Gambia being interconnected to Senegal had a grid failure. It happens, but that grid failure had an impact on the grid of Senegal. So the interdependency here produced an impact between the relationship between the IPP and the Senegalese utility. You had a dispute to settle, or at least discussion. They didn't go all the way to arbitration, but it was a bit of a wake-up call for transactional lawyers, because we realized that even the contractual structure between the IPP and the utility was not managing a risk of a neighboring country for a grid failure, which was hard to qualify as a force majeure because it was foreseeable. It had happened in the past. But who in this situation will pay for the electricity that was not delivered, whether it was the IPP that would need to take that loss, or the Senegalese utility that would still pay for electricity that was not delivered. They ultimately found a solution, but it was one of the first moments where we see that the contracts had not anticipated an interdependency. And as we will discuss, I think you can foresee that this could happen in the region, the Southern African region as well. So if we're looking at the current trend for renewable energy, until now, especially outside of South Africa, we could add renewable energy into the grids across the continent without having to significantly impact the stability of each of the grid. As we are moving towards a greener future, if the renewable energy penetration is increased, you're increasing the potential and stability of the grid for each of the country, where you go above, the rule of thumb is about 20 to 30% of renewable energy. That creates new interdependency, and it's also creating a lot more actors. Conventional energy sources can be concentrated. You can build bigger power plants with a lot more energy, so you don't necessarily have to increase the number of actors. If you increase renewable energy, you're most likely to increase the number of actors and multiply the stakeholders, because you don't want to have all your solar energy into one location in your country. You need to stabilize the grid. And that need for stability is going to lead you to increase the number of actors and force you to anticipate some interdependency that you didn't have. As you know, the sun shines when it wants, the wind will blow when it wants. One of the ways to counter that instability that the renewable energy is bringing is to deepen the integration of the region. So what we have seen as one of the trends is that you will want to have not only South Africa or one of the countries like Zambia having all the solar energy, you want to start to spread it and allow countries to share the energy resources that they have, because that's the way that you bring more resiliency. But it's also the way that you bring a lot more actors and stakeholders within your own relationship between the utility and the IPP, increasing the risk of a dispute. So deepening the grid integration will bring more interdependency, and more potential for dispute. And this is a reality of the energy transition as we move towards more greener energy sources. And then the best example for interdependency is when we get to green hydrogen. So DLSF is currently working in Namibia and Egypt on green hydrogen project, and we're starting to see the structure develop. But what we can tell you already is that when you had some complexity at the level of the IPP, the renewable energy IPP, when you bring a green hydrogen project, you are multiplying this significantly. Because if you assume a vertically integrated project, you will have the power production at this level, you will have the facility to create the green hydrogen, you would have the storage units that are typically within the ports, and you would then have your off-takers that could be within your country. If you're in South Africa, Sasol uses a lot of hydrogen, and potentially green hydrogen. But if you're in Namibia or Egypt, you will want to export. So your off-taker, in addition to be a new party to the relationship, which you didn't necessarily have with a renewable energy project, your off-taker is outside of your own country and will also be an interdependency that you need to take into account. And I don't want to get too much into the details of it, but one of the other aspects and feature of green hydrogen project is that they're extremely capex intensive. And that means that when you do start the construction of these projects, the delays will have a really significant impact on the viability, the commercial viability of the project. So in addition to have to deal with all of these potential actors, or at the very least, different constructor, because it could be one owner of the full value chain. Even if you have the same owner, you will still have to deal with a series of different constructor for the same project, and each of the components will depend on a timely delivery of such project. So these were a few examples that set the table for a discussion that shows how the interdependencies are really a source of dispute and can potentially lead to a lot of work for this room. Thank you.
Thank you, Gadi. That was, I think, very interesting to see what's the development, and you referenced Namibia and Egypt in particular from a green hydrogen perspective. But if you look at some of those projects, what do you see as the means of dispute settlement that you've seen based on your personal experience?
Yeah, so one of the issues not the issue, but one of the trends we're seeing is the more you add complexity in the technology, the more the lenders of these projects want to simplify or to get comfortable with the rest of the project, including the dispute resolution mechanism and the seat of arbitration. So we're seeing that the complexity that the energy transition is bringing and these new industries are bringing is actually has a tendency to bring the seat of arbitration towards jurisdiction that the lenders are the most comfortable with, so towards London or Paris or even New York. And this is something we are, as an African institution, we're trying to argue against, but it is a bit of an uphill battle for the first projects.
Okay. Thank you, Gadi. So we'll obviously unpack that in a bit more detail later on when we have a more open discussion. So the next panelist that will be taking over and discussing it more from a lawyer's perspective is Natasha Peter. Just a quick introduction of Natasha before she starts her presentation. Natasha is a duly qualified English barrister and French advocate. She's a partner in the Paris office of Trinity International, as well as a member of a leading London environmental law chambers, Cornerstone Barristers. She has over 20 years experience in international arbitration, litigation, and dispute management, with a particular focus on disputes in the renewable energy sector. Natasha, over to you.
Thank you very much, Jackwell, and good afternoon, everybody. Bonjour à tous, bonjour à toutes. I am delighted to be here. First of all, an apology. I have a notoriously soft voice. I hope everyone can hear me. If there are any difficulties, just let me know. And what I would like to do, as Jackwell has said, is essentially follow on from Getty's excellent presentation, which has set out some of the complexities of the energy transition, and really focus on the impact that that has on disputes and also on the dispute resolution mechanisms, arbitration, but also other things that are going to be appropriate in the sector. But really, as a starting point, I wanted to start out by underlining the sheer scale of the energy transition that is going to be needed in Africa and globally, of course, as well. Because Africa itself has the lowest carbon emissions per capita of any region in the world. But Africa is also disproportionately experiencing the effects of climate change already. So really, Africa is necessarily implicated in the energy transition. And so what I've done on the first slide is just to cite two of the reports of the International Energy Agency. The first one has just come out, September 2023, on financing clean energy in Africa. It's a complex report, but one thing that one can draw from it is some statistics as to the current situation. Currently, Africa accounts for around 20% of the world's population, but it attracts less than 2% of its spending on clean energy. I could also add that Africa has 60% of the best solar resources globally. It only has 1% of global installed PV capacity. So really, this does need to change, and it's going to change. And the second IEA report that I've cited is the Africa Energy Outlook 2022. And that's also a complex document, but what it essentially does is model what is necessary for what it calls the Sustainable Africa scenario. And that's essentially a model to describe what is needed in order to achieve by 2030, on time, in full, both Africa's energy-related goals and its climate-related goals. So firstly, universal access to energy in Africa. And secondly, all African governments meeting their climate goals under the Paris Agreement as set out in their NDCs, their nationally determined contributions. In order for that to happen, primary energy supply is going to have to rise by over a third by 2030. And renewables is going to have an enormous role to play in that. And in the IEA scenario, renewables account for over 80% of new power generation capacity to 2030. So in terms of financing the volume of projects, these are crucial goals and they're going to have an enormous impact. I'd like perhaps to get everyone out of the post-lunch slump just to do a quick poll. So if you could get out your Slido apps, if you don't mind, and join the Slido. And what I'd like is the audience's opinion as to the total amount of financing that would be needed per year, per annum, to meet the Sustainable Africa scenario. So as a reminder, that's universal access to energy in Africa, and all governments meeting all of their climate-related goals on time and in full. And we're coming in at $1 trillion. Any advance on $1 trillion? As a hint, it's not quite there. It's not quite as bad as that. So we have $1 trillion moving down, 200 billion moving up. Let me put on the next slide then. which provides you with the answer. I don't know if you can read the figures, but you'll see that the third column is 2026 to 2030, the annual investment needed for the sustainable Africa scenario. And it's 200 billion USD per annum. For those of you that said 45 billion, you were almost correct. The green bit, you'll see, is the investment in renewables specifically. And that's about, I make it about 45 to 50 billion. So it's not quite $1 trillion, but it is an enormous investment. And so we're talking about an enormous number of new projects in a very, very short space of time. And of course, it's not just new projects. In order for that to happen, there's going to have to be a ramp up in electricity grids, changes in supply chains, increase in production of raw materials. Critical minerals, for example, is a huge issue. But also the people skills, so the expertise in very, very different fields that people are going to have to develop. So underlining then that there is a huge need for innovation, and there's a huge need for projects to be constructed quickly and efficiently. At the same time, of course, when everything changes and when things happen quickly and when there's a lot of innovation, the corollary of that is a huge potential for disputes. So what I wanted to do in the time remaining is just to underline some of the features, some of the ways in which these disputes are going to be different from the types of disputes that we as energy lawyers, as dispute lawyers, are used to dealing with in the past. The starting point and the most obvious difference is obviously the technology involved. Of course, any construction project, any infrastructure project is going to have technological issues. But I think there are particular challenges posed by renewables. And the main reason is essentially the question of innovation that I've already referred to. It's going to be rapid development in things like floating wind and solar, battery storage, green hydrogen, smart grids, all the things that Gadi was referring to. And that is going to happen in unpredictable ways. We don't know yet what the solutions are going to be. By 2050, we need to know what those solutions are. But what I put in the slide is interesting as well, because even in respect of things like onshore wind and onshore solar, which by now are mature technologies, and everyone thinks that they know how they work. Well, because the pace of change has been so phenomenal in terms of efficiency increases, decreases in cost of production, and so on. There are also huge technological developments that are involved here as well. And the slide is just to give you some indication of the increase in size in wind turbines in just a very few decades. So if that's what's happened in the space between 2000 and now, 2025, can you imagine what's going to happen between to date and 2050? Secondly, though, there are particular challenges that are posed by the fact that renewables are becoming more widespread. And that links back to the question of intermittency that Gadi was referring to earlier. As we develop past a tipping point, we're going to get to a situation where there is a risk of unsustainable, unreliable power systems. So the systems themselves need to evolve. We need flexibility in the grids, we need storage solutions, and so on. So all of this does create a huge potential for disputes, firstly in terms of first-of-a-kind technologies, obviously, but also the upskilling of the workforce, the creative solutions that people are going to have to put in place, and the changes that are being made to the supply chains. So as disputes lawyers, we need to be equipped to deal with these, firstly in terms of new contractual solutions, but also just in terms of our understanding of the underlying technologies themselves. So firstly, arbitrators. When we're sitting as arbitrators, we need to be aware that one of the great strengths that parties see in arbitration is really just the fact that they can choose you. You can decide on the right arbitrator for the right job, But then when council is choosing arbitrators, that means that they can't just go for the usual suspects. They need to make a proactive choice of someone who has the right subject matter expertise. And we talked earlier about the need to Africanize arbitration. That goes without saying, but at the same time, we also need to technologize arbitration. Secondly, in terms of party and tribunal-appointed experts, these, in my experience, are absolutely invaluable. And it is the way of educating a tribunal, assuming you don't have a tribunal that knows everything about a cutting-edge technology, which you're unlikely to do. They can, if they present their position with clarity and conviction, have an enormous role in the success in an arbitration dispute. But thirdly, us, counsel, we ourselves can't be complacent. We can't rely on the arbitrator. We can't rely on the experts. We need ourselves to be able to put ourselves in the position to challenge the opposing party's case, to cross-examine the opposing expert. And so we need a first-hand understanding of the new technologies that are involved. The second feature that is striking in my experience about clean energy disputes is the sheer number of stakeholders that are involved in the disputes. And I'd refer you back to Gaddy's slide, which sets out very clearly the complexity of a single project finance transaction. You have the project company looking upwards, you will have the sponsors, the lenders, the off-taker, the government acting as regulator, and so on. Looking downwards, you have a whole supply chain, suppliers, subcontractors, employees even, etc. But it's not just that, of course, because these are distributed projects. They are often located in remote areas. They're for the benefit of the local community, and they can therefore be extremely positive impacts on a local community in terms of job creation, in terms of localized energy production. But there's also huge potential for damage, and there can be negative impacts if questions of land use, job creation, environmental concerns are not dealt with sensitively and appropriately. So all of this can give rise to disputes. Another striking feature is the role that is played by concessional finance. Firstly, of course, because everyone is now aware of the importance of the energy transition and the need to support it. So there is a large amount of concessional finance available. But secondly, in the African context, there is a particular issue with cost of capital for these projects. And in particular, on average, and it varies, but on average, cost of capital is about 2 or 3 times higher than in developed countries. And typically, it's even greater for smaller projects than for bigger projects. So there is a huge difficulty with access to finance, and concessional finance can play an important role in unlocking that finance. But then it needs to go hand in hand with private capital as well, because there's simply not going to be enough concessional finance to build all the projects that are needed. So this does change the dynamic of disputes. You will have financial innovations, for example, things like guarantee providers, hedging products, and so on. But you will also have a large number of stakeholders who are going to want to participate in the dispute process itself. In addition, in terms of relationships, these are projects where the state often plays an important role. Firstly, as off-taker, and there is an element of risk involved there, and a lot of disputes do, in my experience, arise simply because off-takers are in such a precarious financial position. 1 in 3 utilities in Africa is able to cover their operational and debt service costs. Once again, that's a figure from the IEA. Secondly, governments are also involved as regulators of these projects. And I think we're all aware by now of the risks that that can create, in particular in terms of the disputes under the Energy Charter Treaty, due to changes in financial support mechanisms for solar projects in Spain, in Europe, and elsewhere in the world. So multiple stakeholders do give rise to multiple potentials for disputes if the relationships are not well managed. But also within a dispute, if you have a dispute with a third party, they do also give rise to complexity in the decision-making process of the dispute itself. And we all know that multi-party and multi-contract disputes are one of the most difficult issues in arbitration. We can't try to solve that now, but I think what is important to bear in mind is that you need to think about this from the beginning of your dispute, and ideally from the negotiation of your disputes clause itself. So finally then, in terms of the challenges that I can see in clean energy projects, the third challenge is simply in terms of their variety, in terms of scale and size. Just looking at solar, that can range from the Noor Power Station in Morocco, largest concentrated solar plant in the world, over 500 megawatts, construction cost of over 9 billion. On the other hand, you have an enormous number of smaller utility scale plants, which are maybe a few tens of megawatts, and then mini-grids, which are even smaller than that. They're distributed, they are located in remote areas often, they're complex, and they still have the same potential to go wrong as, say, a nuclear plant or an LNG terminal. So what does that mean for us as dispute practitioners? Well, I think it means that we ourselves need to be as flexible as our projects, and we need bespoke solutions. I've included a quote on the slide from the SOAS 2022 survey on arbitration in Africa. Arbitration is still gold standard, but as we heard from the second panel, there are a lot of alternatives and we need to be alive to those. And for arbitrations itself, the beauty of arbitration is obviously its flexibility to deal with this type of issue. Judge Wallace spoke this morning about the need to cast off the shackles of traditional litigation practices. We really can do that, and that is needed even more in the clean energy context. So, for example, where there's a need for urgent relief, more and more arbitral institutions now have the possibility of emergency proceedings. I've just completed one of those, and it was extremely effective in discouraging the opposing party from pursuing some parallel court proceedings in the DRC. So in the right circumstances, very effective. If you have a smaller dispute, the answer might be expedited arbitration. If you have a dispute with an easy answer, the answer might be early determination or summary judgment. But in any case, the answer is always going to be alive to the possibility of flexible and bespoke solutions. So they do exist, these solutions, but we do need to use them. And in conclusion, just a quote that I think has been attributed to Barack Obama: we're the first generation to feel the impact of climate change and the last generation that can do something about it. So this is important.
Thank you, Natasha. I think that was insightful. I'm not sure if all of you got the answer to the question or the poll. So the answer, I think most said $1 trillion per annum that is required. And the correct answer is about 200 billion per annum. So you guys you are very optimistic in terms of the amount of money, but it's still a lot that is required. About 200 billion US dollars required every year to actually get the African continent out of the what we would call energy poverty that we're currently experiencing on the continent, to make sure there's access to everyone. Thanks, Natasha, for that great presentation. So next panelist is Professor Uche Ofedile. Professor Ofedile is a senior fellow of the Mosvar Rami Center of the Business and Government at Harvard Kennedy's University, Kennedy School of Government, and the E.J. Ball Professor of Law at the University of Arkansas School of Law. Her teaching, research, and scholarship focuses on intellectual property law, international dispute settlement, food law, international investment and trade law, and Business Law. Professor Fedile is an elected member of the Council on Foreign Relations and the American Law Institute. She is also the Deputy Head of Research and Documentation of the Nigerian Bar Association Women Forum and an Honorary Fellow of the Asian Institute of International Financial Law. In Hong Kong, Professor Fedile has authored over 100 book chapters, articles, and essays on different aspects of IP law. Over to you, Professor.
Good afternoon. I know it's after lunch, but that's no excuse for you to sleep. So I know what I tell my students. I call on students in my class, and you know the students I tend to call upon, those that I catch sleeping. So my eyes are on all of you. If anybody is sleeping, I might just call you, okay? So you're one. And I think, you know, we professors, we talk a lot. So I think I have about 3 hours. So just make yourself comfortable, okay? So my topic is on ESG, but in particular, I'm talking about climate litigation and environmental litigation. And it really builds well on what the previous speakers have talked about. I'm just looking at climate change dispute and arbitration with a focus on Africa to look at the trends and to look at the future and to assess readiness. So in terms of that, just 4 issues that I plan to talk about. What types of climate or environmental disputes are we seeing in Africa today? What type of future environmental climate disputes are we likely to see? What is the legal or regulatory basis for the current disputes? And finally, what are we ready? So those are the 4 issues I plan to talk about. And of course, as I was getting ready to prepare for this event, the news flash about 2 or 3 weeks ago was that the California state, the governor of California was bringing an action against the 5 major oil companies for climate change and saying that they basically deceived everybody. They knew the impact of climate change, but for a long time, they did nothing about it and they told us everything was okay. I'm like, wow, that could also be a lawsuit in Africa. So that was it. And then of course, we know a few years ago in 2021, the Dutch court issued a landmark decision requiring Shell Oil Company to reduce their climate, their net, emission standards. That was a decision too that has implications. So how do you define climate change dispute? The ICC defines the climate change dispute as any dispute arising out. I'm going to move to the other one. This one keeps shifting. Any dispute arising out of or in relation to the effect of climate change and climate change policy, the UN Framework Convention on Climate Change or the Paris Agreement. Another definition includes cases that raise material issues of law or fact relating to climate change mitigation, adaptation, or the science of climate change. So are we seeing climate change litigation and disputes? Are they rising? Across the globe, it turns out that we're actually seeing a growing number of climate change disputes. According to the database by the Sebin Center that is located at Columbia University, altogether, they have about 2,341 cases in total dealing with climate change. Of that, about half of those cases, or even a bit more than half, were filed since 2015. In other words, from 2015 to today, we've seen really a growth in the number of climate change disputes. 190 of those cases were filed in the last 12 months. Majority of those cases are in the global north, but we also have a growing number of cases in the global south. About 135 cases in the global south total, 50 of those cases filed since 2020. Okay, what about, and that's, as you can see, a good number of those cases have been filed in the United States, but we also have, as I said, a growing number in the global south. So that's the map that they put. And as you can see, Africa is still kind of blank in terms of climate litigation, but we have a few spots in Africa. So what is the trend in general in Africa? Altogether, there are about 10, maybe more. And at this point, I'll say if you know of any cases that are not reflected in my presentation, let me know, because this is a work in progress. So about 10 cases in total. South Africa leads the pack with about 5 cases. Then we have Nigeria and Kenya, Uganda, Tanzania. Most of those cases have been filed in domestic court or tribunal, and 2 cases were filed in a regional court or tribunal. Most of the African cases are not based specifically on climate adaptation or mitigation. Most of those cases are more broadly about environmental issues, about human rights. So a good number of those cases are just based on fundamental, on constitutional law, on regional law, and most of those cases raise issues about human rights, the right to the environment, the right to clean air, the right to right to health. So a good chunk of the cases that we have in Africa right now do not specifically talk about the science of adaptation, but they're saying that oil pollution, the oil companies are damaging our rights, okay? So that's what, and then we see a few cases, about 4 cases or 5, that deal with environmental impact assessment or the lack thereof, or the insufficiency of environmental impact assessment. Right now, most of these cases are based, as I said, on the Constitution, on domestic law. They're not always based on the climate change law, because most African countries still lack comprehensive legislation on climate change. But people are getting creative. And who is the typical plaintiff or complainant? They tend to be individuals or NGOs or communities. We're yet to see a lot of cases involving companies or private entities. We're yet to see those cases. So I'm just going to go through some of these cases. I will not drill deep into them because my time is short, but in my paper, the details are there. So these are some of the cases. As you can see, a good number of them are from South Africa, and most of them have to do with impact assessment, as I've said, or lack thereof. The most recent is from the 2023 from the High Court in South Africa. And then again, I'm not going to go down through all of them. These are also some of those cases. For example, the Sustaining the Wild Coast is all about the grant of an exploration license. And some of those cases, the courts have said that the environmental impact assessment was insufficient, or that some of them are about just stopping the issue of a licensing, a mining license to a company. So they're just in various forms. And we have, for example, the case in Kenya, where it was about the construction of a coal-fired power plant. And the argument was that the EIA was inadequate. And the tribunal agreed and said that, the tribunal basically stopped, the construction. And the tribunal said, the company, you have the right, you can conduct another environmental impact assessment, but in your EIA, you have to include the impact on climate change. So some of these, again, just to repeat, some of those cases are broadly about environmental rights, are broadly about human rights, are broadly about environmental impact assessment or lack thereof. We are yet, and then another group of cases are the cases from companies against the state. According to the UN, the UNCTAD, there are about 175 cases that involve environmental cases in the ISDS, especially those that are based on IIAs, the International Investment Agreements. And what we're seeing, even though not specifically in Africa, that when countries are trying to transition, maybe by a ban on mining or a ban on any kind of ban, that as you transition in this whole energy transition, that can raise the risk of lawsuit, that can raise the risk of ISDS. And I think we're going to see that in the future. If the speakers, what they've said, that Africa needs to step up in terms of transition, while Africa is not dealing a lot with mitigation, as it deals with transition, we might see governments taking more drastic steps, and that might in turn trigger investment dispute settle cases. And I think in most of these cases are going to be based on either expropriation or, some other clauses in the BIT. One unfortunate, or you might say unfortunate, is that even though African states are on the path of BIT reform, a good number of the cases that are coming up are based on old BITs. And many of the African countries have a lot of old BITs. So even though we have some new BITs that talk about environmental issues and climate change, most of them are not going to be what any future dispute is going to be about. Okay, moving on. So I've talked about what the current disputes are about. Based on what we see in other countries, what are the likely future disputes? And based on other countries, I think you can say that the future disputes, we're going to see, maybe a growing number of commercial, contractual cases that deal specifically with climate change or supply chain. We're still going to see a lot of human rights and constitutional rights cases, but we're going to see more cases that actually challenge the domestic enforcement or non-enforcement of climate-related laws and policies. I believe that we're going to see more corporate liability cases that are specifically about corporate liability for climate harm, just like the one that was filed in California recently. I think we're going to see more cases that are aimed at keeping fossil fuels in the ground, to the extent that the governments are not moving ahead, as fast as they need to. We might see more cases like that. And failure to adapt, I believe we're going to see more cases like that too. Disclosure cases. Around the world, we're seeing more and more disclosure cases. What do we mean by that? There are laws that are requiring companies to disclose, their climate efforts, their net zero. Those kind of laws may become the basis for future disputes. We're seeing stock exchanges around the world actually having disclosure rules, and some of those are coming to Africa, as I'm going to show in the next slide. So in the future, based on just a survey of current disputes around the world, there are climate migration cases, there are pre and post disaster conditions that relate to climate change. We're seeing flooding and drought all around. So more specific cases might come up, even transnational responsibility cases are going to come up. I'm going to I think that in the future, we're likely to see an expanding list of targets. Right now, we just have cases against the government and a few cases against companies. I believe in the future, we're going to see more supply chain participants being the target of lawsuits and disputes. The carbon majors, I think we're going to see more disputes. Even beyond the carbon major, there are so many companies that are not necessarily carbon major, but they are also involved in climate issues, and they have businesses that impact the climate. I believe they're going to be targets too. Subnational entities and financial intermediaries. Right now, so when a bank is funding a project, and that project is having impact on climate, then they become target for future disputes. I know a few years ago, the IFC, part of the World Bank, was sued. That was by communities in India for human rights impact of the project that they funded. So I'm thinking that in the future, we're going to see financial intermediaries becoming targets. And we're going to see more personal liability cases where board members are actually the target of lawsuits, okay? So this is from the Sabin Center, and they show the number of cases against corporations by sector across the globe. And as you can see, and maybe you cannot see it, you see that the fossil fuel industry are the largest, but the number of other sectors are also fair game. It can be insurance, it can be banking. A lot of other sectors can become fair game in the future dispute. I'm going to just speed up because he's telling me I'm almost out of time, right?
Time is up.
Okay, so my time is up. Sorry. Thank you.
No, thank you.
Thanks, Uche.
Thank you, Prof. I think we would have wanted to listen more to that, but hopefully, I think any of the audience members, if they want to, they can afterwards have a good discussion with you. Then our last presenter, because also we are running out of time for the program also, is Pierre Berger, who is a partner at Worksmans, dealing with commercial disputes across a range of sectors. He will be talking on cryptocurrencies. So I'm just going to hand over to you, Pierre. Sorry for the short introduction, just time.
Thanks, Jacques. We're talking about new kinds of disputes arising from emerging technologies. And one such technology is, of course, blockchain, which has assumed enormous prominence both in commercial activity and in the public eye. When we're talking about blockchain, let's get straight to the definition of that. It is defined as a distributed ledger which consists of growing lists of records or blocks, records of transactions that is, that are securely linked together via cryptographic hashes. Now, what is a distributed ledger, you may ask? Well, there are various definitions, but essentially it's a distributed database. It's a database that isn't centrally held. It's held by each participant in the system. It's updated independently by each participant or node in a large network. It's also defined as the consensus of replicated, shared, and synchronized digital data that is geographically spread or distributed across many sites, countries, or institutions. This concept of consensus is key because one of the biggest selling points of blockchain technology is that there's not any room for dispute about what was transacted on that system. It's all transactions in blockchain technology are verified and are theoretically immutable. It's also been defined as a platform that uses ledgers stored on separate connected devices in a network to ensure data accuracy and security. Now, blockchain technology is the foundation of the phenomenon of crypto assets and cryptocurrency, which is a form of crypto asset. A crypto asset is defined by the UK government definition is a cryptographically secured digital representation of value or contractual rights, which uses a form of distributed ledger technology and can be transferred, stored, or traded electronically. The EU definition in the Markets in Crypto Asset Regulation is essentially similar. The key factor about a crypto asset is that its ownership is cryptographically proven. It's not guaranteed or issued by any bank or public authority. The best known crypto asset, of course, and I'm sure you all know about Bitcoin, a digital currency which is based on blockchain technology. Blockchain technology, as we've seen, removes the need for a central authority, such as a bank, to check for invalid transactions because the transactions in the blockchain are validated by all of the individuals participating in the system, solving computational puzzles which validate the transactions and tie a ribbon on them and add them to the blockchain. Crypto assets have various functions. They can function as currency between parties who agree to use them as such. They can function for investment purposes. They can also function as utility tokens. But most commonly, a crypto asset, any given crypto asset, will have a hybrid function. So it can be part currency and part investment. And it also depends very much on how the users in the system prefer to use the crypto assets. Now, of course, wherever you have assets, wherever you have value, there you're going to have disputes. And so what I'm talking about now is crypto disputes, and specifically crypto arbitration. I use the term crypto disputes to mean any dispute arising out of or related to crypto assets and crypto businesses, such as crypto exchanges or brokerages. Now, crypto fraud cases are also rife, but they typically don't go to arbitration because there's no way to arbitrate against a fraudster who defrauds you probably anonymously out of your cryptocurrency and then disappears forever. In that case, there's an entire body of jurisprudence that's developed in various jurisdictions around injunctive relief that can be obtained against anonymous fraudsters, tracing of assets, and freezing of crypto assets, but that's not entirely relevant to what we're talking about today. What we're talking about is arbitration, and arbitration is fast becoming the dispute resolution mechanism of choice in the crypto sector, due predominantly to several factors that make arbitration attractive. In this context, firstly, it's neutrality. Secondly, it's wide enforceability via the New York Convention, although we'll put an asterisk next to that because there are provisos to that, and we'll come back to that. But these factors align with the decentralized and cross-border nature of crypto trade. There's also the flexibility of arbitration, which enables the appointment of subject matter experts to act as arbitrators, people who perhaps understand coding. Confidentiality, of course, we all know that the crypto sector places a huge premium on pseudonymity and even anonymity, which makes arbitration more attractive. And lastly, there's the ability to agree upfront to arbitration in online agreements, which bypasses the jurisdictional nightmares that can arise in crypto litigation, where parties are typically situated in separate and possibly even unknown to each other jurisdictions when they transact. The types of crypto dispute, well, they are many and varied. You can get disputes between an investor and a trading platform for the breach of the trading platform's service agreement. The Binance class arbitration instituted in the Hong Kong International Arbitration Center, and which is still ongoing, is a very prominent example. What that's about is that Binance is the world's largest crypto exchange. It was founded in China, but it subsequently externalized to various jurisdictions via a network or a group of a fairly opaque network of companies in various jurisdictions around the world, which perform various functions. What happened is that on the 19th of May 2021, the Binance trading platform went down for some time, and that also just happened to be the day of one of the largest drops in value of Bitcoin in history. So traders were naturally prevented from trying to access the platform in order to try to trade their way out of their losses or to mitigate their losses, and that led to losses, and that led to the Binance class arbitration by more than 700 claimants against this platform. Other kinds of disputes include claims by platforms against investors for payment for crypto assets, or investor platform claims based on mis-selling or misrepresentation regarding the risk of investment, or the assets underpinning stablecoins. A stablecoin, incidentally, is a kind of cryptocurrency that purports to peg its value to a fiat currency, a normal currency, and to maintain stability like that, because as we all know, cryptocurrency is notoriously unstable in value. Payment of crypto-denominated debts. There are financial transactions, for example, failure to return crypto assets provided as security, such as non-fungible tokens. Any kind of dispute really could constitute a crypto dispute. There are investment disputes pertaining to investment in crypto businesses. There are IP disputes, and there are disputes pertaining to the sale of goods, and others. I'm not quite there yet, but okay, I've been asked to wrap it up. So. My paper will be accessible to anybody who wants to have a look at this. It would be remiss of me not to have referred to the issue of on-chain arbitration, which is a term that refers to new forms of procedure that can be anything from online arbitration to crowdsourced dispute resolution, where various participants in the system can volunteer and act as the arbitrator, to AI-powered dispute resolution. And on-chain enforcement is an even more powerful concept that bypasses the need for courts and for traditional enforcement methods by enabling enforcement to take place directly on the chain via an arbitrator empowered to do so. There's a lot more, but please feel free to have a look at the paper as and when it's uploaded. Thank you. There's a picture of me looking several years younger than what I do now.
Thank you, Pierre. And maybe just the last point is we have 2 polling questions, so I think we need to just do the poll before we close. We actually had less time than we planned. We should have had 1 hour and 15 minutes, but we were cut, but it's fine. So I understand. Can we run the first poll, please, before we close? If all of you can just, the poll is, what is required for African practitioners to be ready for disputes in new and future industries? If you can please do your votes, and then we'll have a quick closing by each of the members in 30 seconds. Hopefully that's fine on this. I think based on the majority, it says you need a bit of both. So maybe just a quick remark by each of you in respect of this particular poll. Maybe starting with Gadi as a client and a bank.
Yeah. Interestingly, I think you need to have a good understanding of what's happening in the sector without necessarily being an expert. We've mentioned technical complexity is kind of the new feature, or not the new feature, but it's more pronounced feature of these future industries. So you do need to anticipate where they're going as a practitioner, but I don't think you can necessarily be an expert. And it's also understanding how they interlinked with the conventional and other new future industries. My take on this one.
Thanks, Gary. I think our president wants us to close. So.
One more.
You can find it.
All right, well, I'll just agree with Gary, absolutely. It's what I tell my students. It's not enough for us to be lawyers. That's the traditional approach. We now also have to have an interest in the underlying subject matter. So I tell them they've got to pick something that interests them, because I think the crucial thing is to have an attitude of curiosity towards the industry sector that you decide to specialize in.
Thank you, Natasha. Prof?
Yeah, I think that we need more specialization, especially on climate issues. There's a lot of science involved and a lot of new industries involved, and so that kind of substantive knowledge is very, very important. I'll just add that some other arbitral institutions are already thinking about it. The ICC had a task force to look at the issue of climate change arbitration. And I believe the Permanent Court of Arbitration has also issued an optional rule for environmental and climate change dispute. So these are things that arbitral institutions in Africa need to be thinking about. Thank you.
Thank you. Pierre, final remarks?
Thanks, Jack. Well, practitioners in general, and including African practitioners, are essentially, disputes practitioners are essentially voyeurs. We need to be able to dip into any field of commercial activity and rapidly upskill ourselves and become experts in it so as to be able to effectively engage with those disputes. And I've got no doubt that African practitioners are equal to the task of understanding crypto arbitrations and becoming proficient in them. The only question is, in terms of the on-chain arbitration phenomenon, if that takes off, to what extent that will affect the role of lawyers at all in those proceedings. But that's an open question at this stage.
Thank you, Pierre, and thank you to the panelists. It was interesting discussion from a client perspective to the lawyers, and also from an academic perspective in terms of what's happening on the continent when we talk about new industries and dispute settlement methods that will be utilized and what is required from practitioners. I think we could have discussed a bit more, but we are bound by time constraints. So thank you to the panelists.
Thank you so much, panel number 3. I think you've done very well with the time constraint. If we are looking at our clocks and our watches, we will realize that we're running about 10 minutes behind time. And in a bid to catch up with that time, I'll implore that you all go for coffee now and try to spend no more than 10 minutes. In fact, if you could just grab your coffee and come back in, then that will be good so that we can catch up with time. And there is a drinks reception this evening, and it starts at 6:30 after here. So it may be a sensible thing to just leave here and go straight there, because it's not going to be all night long party. It's going to finish fairly early. So when you are taking your coffee and conducting the rest of your afternoon, please factor that in and bear that in mind. It's only a few minutes walk from here. You could also get Uber, a few seconds to the venue, but we won't disclose the venue right away so that we don't want people to sneak out and go to start getting ready. We'll wait until the end of the day and then we'll tell you the venue. So please, you're welcome to take coffee now and come right back for the fourth panel. Fourth panelists, please do get ready to come up and do your panel.